we're going to get started. Well, thank you all for joining. My name is attorney Wendy Guthro. I'm a licensed practitioner in Massachusetts and New Hampshire. And today we're going to talk everything about wills and trusts and which is right for you and for your estate. So I'm going to open up a PowerPoint presentation to help guide us through this. And so we're going to talk about a will versus a trust, which is right for you. As I said here, I'm Wendy Guthro. I'm a licensed practitioner of law in both Massachusetts and in New Hampshire. My main focus is in estate planning, elder law, probate, and trust administration. I'm a member of the National Academy of Elder Law Attorneys in Massachusetts, and I'm admitted in both the federal and state bars in both Massachusetts and in New Hampshire. So the objective of this webinar is to understand, or this presentation in general, is to understand the difference between a will and a trust and recognize the benefits and limitations of each option depending upon which way you go. So as I said to people earlier, if you want to mute your phones or have something to sip on, we're probably going to run about a half hour. Sometimes it goes a little longer. The outline of this is to understand first the terminology that I'll be speaking and referencing. Then we'll go right into a will, what it is and the pros and cons of having a will. Then we'll go into the trusts and the benefits, the types and benefits of trusts, revocable and irrevocable, and why you might want either one of those. And then number 4 will be the differences in the process after someone passes away, say if you just had a will versus if you had a trust or both. And then we're going to speak about the role of the personal representative versus the trustee. And that is a personal representative is the person under a will versus the trustee is the name of the person that's going to oversee your trust after you pass away, if you have a trust. Then we'll roll into which one is right for you and a little bit about what the process is to start having a will or a trust. And then I have some commonly asked questions. So we'll do some questions and answers. And then I'll open it up to the floor for any of you that have an individual question of your own circumstances or a general question that you have from the presentation material. We do have an open chat. You could put questions in the chat and I'll go and read those afterwards. We also have the ability to raise your hand while we're going along, but it's easier if you just kind of either jot your questions down in the chat or on a piece of paper, and I'll be able to answer those for you at the end of the webinar. Okay, so to start with, there are certain documents that I recommend as an attorney for all of my clients to have, and I refer to them as the cornerstone legal documents. There are 6 documents, as you can see here on the slide: a will, a revocable living trust, a power of attorney that handles finances for someone when they're incapacitated or alive, or whether they have capacity, but you need to be alive to use a power of attorney. A healthcare proxy, HIPAA, and advance directive, and a living will. This is a graphic depiction of those same 6 documents. So you can see the will and the trust, the first 2 documents on the top line are what we're going to speak about today. The third document is a power of attorney. We don't really talk about that much today, but it's a very crucial document to have where someone is in charge of managing your finances on assets, maybe that are not held in a trust. So all of your assets, if you just have a will, during your lifetime when you're alive, but you cannot manage your own financial affairs. And then the bottom 3 documents are your healthcare documents, your healthcare proxy that most people have, are familiar with, because whenever we go to a hospital or a doctor's office, they'll ask us, oh, do you have a healthcare proxy of someone that can make healthcare decisions for you when you're not able to make them for yourself? And then the HIPAA is who can get at your protected healthcare information. And then your advanced directed living will is where you select what you would like for your end of life care, whether you'd like to be kept alive on life support for any number of days or an infinite amount of time, or whether you want all life support materials to be withdrawn so that you can just pass naturally. So the first two documents in this depiction are what we're going to speak about today. So I said we were going to start with terminology. This is the first part of our outline. So a will, what is it? It's a legal document that distributes your assets after you pass away to the new owner using the probate court system. So the new owner is who you would have maybe met with me, and we would have discussed who you'd like to be in charge of your estate, who you'd like to receive your assets when you pass. That is called a beneficiary, who's going to receive their inheritance. So that is what a will is. It's a legal document that distributes your assets. It is only used and it only comes into fruition once you pass away. So there are a lot of things we don't really put into a will versus a trust. We would put a lot of things, but on a will, we're only dealing with things that concern your estate upon your passing. Now, a will, you have to bring the will, if you have one, to the probate court upon your passing, if you have any probate assets, which we'll go into in a few moments. So I want you to walk away from this slide understanding that a will is brought to the probate court to open it up and start the probate process. So a will does not avoid probate, but a will opens up probate. There are three parties to a will. The principal, normally you, the person who creates the will. The second person is called the personal representative. It used to be called executor or executrix, but the law changed about 10 years ago, and we now refer to this person as the personal representative. That is the person that you have appointed to follow the directions that you have outlined in your will, and they will deal with the probate court and make sure between the personal representative and the oversight of the probate court that your wishes that you've memorialized on your will are going to be met. The third person is the beneficiary. Everybody likes to be the beneficiary. That is the person who's going to receive the inheritance. They're going to benefit from your estate, in turn, beneficiary. So those are the three parties to a will. Terminology again. What is a trust? A trust is a legal entity that can hold your assets during your lifetime and distribute them during your lifetime as well as after you pass away. But the biggest difference with the trust is that we are doing this distribution of your assets without using the probate court system. So a trust is simply a container to hold things where you are then going to name the people that you want to follow the directions that you've written down, the trustee. And again, just like on a will where you had people that were going to inherit your assets, the beneficiaries of a trust are going to be the same. They're going to inherit your assets, but they don't call it an inheritance when it's a trust. They are simply beneficiaries. Now, beneficiaries of a trust can be beneficiaries during your lifetime because a trust is something that you use during your lifetime, not just when you pass away. So the three parties of a trust are one, the grantor, normally you create the trust, and then you transfer your assets into the trust. So you're the grantor because you're granting your assets into this trust container. And the trustee is normally you if you are the grantor, and that You can name successor trustees after you're gone that can take over upon your incapacity or your passing. And then the beneficiary is, again, like I said, with a will, very similar. They're going to receive your assets during your lifetime or upon your passing. What is probate? Because we spoke earlier about a will and that it involves probate, but that a trust does not involve probate. So probate is the legal process to retitle assets into a new owner's name using the probate court system. And you go to probate whether you have a will or you don't have a will, because some people die without a will. And then we are going to have the laws of Massachusetts or New Hampshire, in this case, determine who gets what upon your passing if you haven't chosen through a written document of a will who is going to be the beneficiary of your estate and who is going to be the personal representative to oversee the distribution of your assets in your will. So, what is probate? It's a legal process to retitle assets into the new owner's name, and we're going to involve the probate court to oversee the process, along with the personal representative that you've either appointed in your will, and if there isn't a will, that the court has an order of appointing people for you. Why do we want to avoid probate? I'm sure many of you have heard this. You don't want to go to probate. Well, why? Well, one is that every document that you submit to the probate court is a public document. It's part of the public record. So if you have privacy concerns and you don't want your will to be out there for all the world to see, if you don't want to show that you might have disinherited an heir or someone, or that maybe you have a special needs person in your life and that you're making a special distribution through a special needs trust through your will. If you don't want any of that to be known, then you want to try to avoid probate. Also, probate in general is a costly endeavor, mainly because it takes at minimum 1 year to get through the probate process, because you have to leave probate open for creditors to make a claim against your estate. And they have 1 year to make that claim from the date of death. So because of this lengthy process, and because there are often a lot of people involved, you're going to have to inform everyone that could be a potential beneficiary. We need to send a copy of the will to all of the beneficiaries. And then we have to get their approval of whoever has been appointed the personal representative in the will. All of those things have to be returned to the personal representative and oftentimes the law office. And then we are then submitting all that documentation to the probate court. Then we are going to be paying all the debts of the estate, all with the blessing of the probate court. And then finally, after all that is done, we're going to be making distributions to the beneficiaries that are named. So why do you want to avoid probate? If you have privacy concerns, because of the cost, the time involved, and also that Mass Health Medicaid claims for any type of long-term care in a skilled nursing facility, or just about anyone that receives any special benefits through Mass Health through the Medicaid process. Medicaid and Mass Health are made whole and reimbursed through the probate process. So that is a big reason why a lot of people, especially those on public benefits, are trying to avoid probate. Section 2 on our table of contents was the pros and cons of a will. So first we've talked about some terminology. Now we're going to do a deep dive into just wills. So the pros of a will: asset distribution. It ensures your assets are distributed according to your wishes, right? Whomever you have named that you would like to receive those assets. It minimizes family conflicts over an inheritance when you have a will, because you have literally memorialized in writing who you would like to receive your assets and in what percentages you would like them to receive it, or outright specific amounts of dollar amounts. But normally, when I'm drafting wills, I do prefer that people look at all of their assets. Say you have a total of $100,000 and you want to say you want 20% of your estate to go to this person and 40% to go to this person and another 40% to go to that person. So instead of using specific amounts, if you want to distribute 100% of your estate to a fixed number of people, then it's best to use percentages. But in general, having a will and memorializing what your desires are, that in itself goes a long way in minimizing family conflicts over inheritance. They may not be happy with the decisions you made, but legally you have memorialized them, and the probate court is going to be overseeing those distributions. So it likely is what it is, whatever you've written in your will. Having a will also allows you to designate guardians for minor children within the will document itself, as well as ancillary documents. You can help minimize estate taxes with some tax planning that can be built into certain wills. And that having a will provides reassurance and clarity for you, yourself, if you are the person who is the principal, created the will. And just that I find that once my clients have taken the time to figure out who they want to be in charge of their estate when they're gone and who they want their assets to transition to upon their passing, it gives you a lot of clarity and peace of mind that that is done and that you can finally kind of move on and worry about all the day-to-day stuff of living. So we just talked about the benefits of a will. Let's talk about the other side, the negative of a will. We spoke about some of these already. It's a public record. Wills become part of the public record when filed with the court, including the amount of money that each beneficiary is going to walk away with, because we do a final accounting that goes into the public record. So you will be seeing in the public record how much money each person received, or what assets. Could be a house would be transferred to them and maybe not money, but whatever it is, those distributions are memorialized in a final accounting in a probate court filing of a will. The cons of a will are that they are subject to legal challenges from heirs. So if you have a disgruntled heir or someone you may have disinherited, that there are processes and systems built into the probate court process that make it very easy for a disgruntled heir to challenge a will. They may not be successful, but there are avenues that are a lot easier to challenge a distribution when there is just a will. The fees and time associated with the probate process, we hit on that earlier. It's limited scope. It does not cover all assets. So a will is only going to cover assets that are probate assets, such as a life insurance policy where you name a named beneficiary. That is not a probate asset. A retirement account where you have named beneficiaries. That will not be part of the probate process. A jointly held bank account with a child or a spouse. That will not go through the probate process. So sometimes it could be viewed as a positive, but oftentimes I find clients that say, I would like my estate to be distributed equally between all of my children, yet they have one child named on a bank account with them. So that particular asset will no longer be part of their will. So it has limited scope. And the cons of a will that it does not govern jointly owned or beneficiary designated assets, which we just spoke about, and that it's not very simple to make updates to a will. It requires formal updates, which means in Massachusetts, you need to do it in front of a notary and two witnesses. So there's added formalities and thus added expenses with updating a will. I mentioned this earlier. Having a will does not avoid probate. Many people believe that if they just have a will, it will avoid probate, but it does not. So while a will is essential for your estate plan, it does not keep your estate out of the probate court system. There are certain ways to avoid probate, and I mentioned some of them earlier, and I refer to these as will substitutes. Now, again, there's positive and negatives to will substitutes. If you want to avoid probate and you don't have a will, you could transfer your assets to someone during your lifetime. And that would be a way to avoid probating assets. Jointly titled assets don't go through the probate process, so we refer to those as will substitutes. Again, it doesn't help in the situation I mentioned earlier. If you have 5 children and you only named one child on a bank account with you to avoid probate, legally, that bank account is the owner of that bank account is that one child who's named on that account with you. Beneficiary designations on investment accounts, retirement accounts, life insurance policies, those are all ways to avoid probate, but they are also considered will substitutes. Payable on death bank accounts called payable on death, transfer on death, taught and trust accounts. Those are all designations that you can add to a bank account where you're not adding someone to the title. You're only saying upon your passing that this is who you would like the bank account to go to. As far as real estate, life estate deeds are ways that you can say that you are the owner of the property for your lifetime. But upon your passing, it's going to go to this particular person or group of people. But what really happens with life estate deeds is that you are transferring ownership of that real estate, of that deed, to whomever you want to add to that deed, and you are reserving the right to live in that piece of real estate for the rest of your life. So there are tax consequences to life estate deeds, but I bring it up here because it is a type of will substitute. And then assets held in trust. Those are also will substitutes, and that's the area we're going to next. So, trusts, types and benefits. So we went into terminology, then we went into the wills, and we went into the benefits and negatives, the cons of a will, and now we're going to talk about trust, types and benefits. We started with this screen earlier. What is a trust? It's a container to hold things. It's a legal entity that can hold your assets during your lifetime and distribute them after your passing without using the probate court system. This is a graphic depiction of a trust. There's the container on the bottom, and it shows that you're the grantor, you're the trustee, you're the beneficiary. This is an example of a revocable trust. And what the goal is to take your real estate deeds and transfer them into your trust. This is something that if I create your trust for you, I take care of transferring all your real estate into the trust. If you have out of state real estate, oftentimes Florida, Maine, Vermont, New Hampshire, we contact attorneys, real estate attorneys in each one of those states to facilitate those deed transfers into your trust. I take care of transferring your personal property into your trust. I give you funding instructions on how to transfer your bank accounts, CDs, your stock and bond portfolios, whether they're held individually or at an investment house, your mutual funds, transfer your savings bonds. So we want to get all of your assets into this revocable trust where you still retain control of all of these assets. We do not normally transfer retirement assets into a revocable trust because that has a tax event connected with that. We'll go into that in a little bit. So again, two different types of trust. We have a revocable trust, which was the example that I just showed you. It's a trust with changeable terms. You as the grantor retain complete control over the trust and all of the assets that are in the trust. It can be modified, changed, terminated. So it's really has a lot of flexibility built into it. So most clients that want to avoid probate and want to keep control over all of their assets, but want to have them in one place to manage, will normally use this revocable trust. The second type of trust is called an irrevocable or an irrevocable trust. Now, this is a trust that has unalterable trust terms. You cannot change this trust once you create it. The grantor, normally you forfeit control of the trust and the assets in it. So it cannot be changed. So most of the time, we're doing irrevocable trust when there is asset protection planning that wants to be achieved. And most often, we use this when we want to provide for special needs or handicapped individuals that are on public benefits, or if we want to start a 5-year look back period for anyone who wants to protect assets in the event they go into a skilled nursing facility, a nursing home with the need for long-term care. The benefits of a revocable trust. It bypasses time-consuming and costly probate, which was section 2 that we went over. So if you create this container and fund it with all of your assets, everything that you get into this trust container will avoid probate. It has a lot of privacy protection because it maintains the confidentiality of the estate distribution details, because this is not filed with the probate court. It's rarely filed anywhere except with the trustee and the beneficiaries of the trust. And it's only given to the beneficiaries normally once you pass away and that they are entitled to a distribution. It allows easy modification of trust terms and can reduce estate taxes, where before on a will, we were saying that it has to have all the formalities of a notary and 2 witnesses to modify a trust. In Massachusetts, at least right now, it's simply in front of a notary. So it's much easier to modify the terms of a trust if it is a revocable trust. It ensures seamless asset management during your incapacity. So you normally create this container when you have full capacity, and then you would transfer your assets into it, knowing what you're doing, knowing that you can take money out whenever you need to, knowing that if you wanted to have some home care or you wanted to buy a boat, that you would just go and write a check from your trust bank account, pay for these items just like you would pay for them currently out of your regular checking or savings account or money market account or brokerage account. But if you become incapacitated and you don't have your assets in a trust, and you just own these things in your individual name, and you become incapacitated, the only way to have someone take over those assets for you in an account that you are the only owner of is to go to court and ask the court to provide a conservatorship appointment over you, because you are incapacitated and don't have the ability to make financial or maybe even healthcare decisions for yourself. So a trust provides planning in the event you become incapacitated. And it facilitates smooth transition of assets to beneficiaries upon your passing. We're not going to probate. We're not involving the probate court. Literally, I have seen people that have a trust that is fully funded with all of their assets. They finish the taxes, they pay any estate taxes that might be due. And at that point, once all of the debts of the estate have been paid, then it's really, if you know there aren't any other outstanding creditors, you can literally turn around and within months start distributing assets from a trust estate. So it really facilitates smooth transition of assets to beneficiaries. So A revocable trust, it's has changeable terms. You retain total control of that container and the assets that are in it, just as you control them now, and that it can easily be modified. Benefits of an irrevocable trust. So first we talked about the revocable one that is normally used for estate planning, when you want to keep total control. Now we're going into the more severe type trust called the irrevocable trust that's normally used for asset protection because it can shield assets from creditors and lawsuits. It can reduce estate and gift tax liabilities because, in essence, you are getting these assets into this irrevocable trust, and oftentimes you can get them out of your estate as well for tax planning purposes. Special types of irrevocable trust called Medicaid Asset Protection Trusts aid eligibility for Medicaid benefits. That does have the 5-year look back period, so you would need to create that Medicaid Asset Protection Trust 5 years in advance of the day you end up having to go into a nursing home. So since none of us have a crystal ball and know when are we going into a nursing home, if ever, then you have to kind of figure out what is the likelihood of one, if you're going to even need long-term care in a skilled nursing facility, maybe look at what age your parents were when they started to decline. Did they need a skilled nursing facility, or were you able to care for them at home? Is there Alzheimer's or memory issues in your family that you know that it's more likely you might need a nursing home? Those are all factors that are considered when you're trying to figure out when you should think about doing a Medicaid asset protection trust, if at all, to start the 5-year look back period. An irrevocable trust facilitates tax advantage charitable contributions. And an irrevocable trust ensures long-term financial support and care for a special needs person, child or adult. So it really does help with some planning for them. So this is the general pros of trusts. Now, they're mixed up for whether you have a revocable estate planning trust or whether you have an irrevocable Medicaid asset protection trust or just an irrevocable creditor protection trust. So both of them avoid probate. Both of them maintain privacy. Both of them have incapacity planning built into them. Both of them can reduce estate and gift tax liability. The Medicaid Asset Protection Trust is the only one that you would use for the 5-year look back period to start that, and then the special needs planning. So those are a lot of the general pros of trusts. Most of my estate planning clients that are looking for revocable trusts are really looking for the top 4 there, that it avoids probate, it maintains privacy, it has incapacity planning built into it, and it can reduce estate and gift tax planning. The difference in the process upon your passing. So we spoke about terminology first, then we went into everything about wills, kind of, and the parties and the players, and then we went into the pros and cons of a will. Then we went into the same situation for trusts, and we went into revocable versus irrevocable trusts and what are some of the benefits of the trust. Now we're going to talk about the difference whether you pass away with just a will or just a trust. So this is again reminding you, a will, it's a legal document that involves the probate court, and it distributes your assets only upon your passing. Where a trust, it holds your money, your real estate, all these different assets, but it's a document or a container that you don't wait until you pass away to use it. You use it immediately as soon as it is created. So I have a trust and I have a revocable trust, and I have transferred the deed to my home into the trust. I have my bank accounts in the trust. I have my brokerage account in the trust. I have actually named my trust as the beneficiary of my retirement assets as well, because I do have a specific type of trust that you can do that. So I will be reassured of not having to go to probate because I created this revocable trust and put all my assets into it. So when I pass, I will rely on my trustee, my successor trustee, to oversee the process. So again, those are the two things we're comparing here, a will versus a trust. Here's a graphic depiction of if you use the probate process, you're going to be taking your will, you're going to be bringing it to the probate court, and with the help of the probate court, your personal representative is going to be making distributions to your beneficiaries after all of the debts and taxes have been paid of your estate. It's costly. It takes at minimum 1 year. It's a public process, and there's no asset protection built into a will. Versus the trust is a non-probate process. We have the trustee, who's very peaceful trustee, and they're going to look at the terms of the trust that you have outlined, and they're going to pay all of the taxes, pay all the debts, and make those distributions to the named beneficiaries that you have designated in the trust. So what people like about the trust is that it can take place immediately. There's no involving the court. It's private, and that you can have some asset protection planning built into even a revocable trust. Let's talk about the role of the personal representative versus the trustee. So the personal representative is using the trust, the will, and the trustee is using the trust. So under a will, the personal representative executes the deceased person's wishes because you have appointed them as the personal representative of the will. They file the will with the probate court. They guides the will through the court process. So this is what your personal representative is going to be working with the court and likely working with the attorney to figure out, when do you have to do things? When do you pay the debts? When do you liquidate particular assets? And then when do you make final distributions to the beneficiaries? The personal representative represents the estate. So they act on behalf of you because you're not here to act on your behalf. So that is the role of the personal representative. They have to pay the debts, the taxes, and the expenses, and then they distribute the assets to the beneficiaries, as I mentioned. So this is the role of the personal representative with a will. The role of a trustee is very similar, but it's done without the probate court. The trustee or the successor trustee, because you are normally the trustee of your trust during your lifetime. They hold and manage assets for the beneficiaries without the probate court. They administer the trust according to the terms that you have written down. They have to follow those trust terms. They owe a duty of loyalty and prudent management to the beneficiaries. So these are the fiduciary duties that come as a trustee, a successor trustee. They make distributions per the trust provisions. So that's the distribute the income and assets. They invest trust funds for beneficiaries' benefits, because sometimes on a trust, you might say, I would like my money to be distributed 50-50 to my two children. And one of the children may not be that great with money. So you might say, either for one or both of your children, I would like a tiered distribution scheme. And I would like my trustee, my successor trustee, to be in charge of that. And I would like 1/3 of my assets to be distributed to my children when they reach the age of 25. And then the following 1/3 at the age of 30, and then the other at the age of 35. Well, who's managing those assets until your children reach those age gates where they're entitled to distributions? That would be the role of your successor trustee. So where you have the built-in fiduciary obligation, and that they have the loyalty and prudent, the obligation of loyalty and prudent management of the assets within the trust. They will be overseeing the care of those assets held in the trust prior to distribution to the beneficiaries. We're going to now go into the will versus the trust, which is right for you. So it depends whether you can get by with just a will or whether you should go the extra effort and get a trust. So what does it depend upon? Your asset type and the value of your estate. Your family structure. If you have a very nuclear family, no second marriages, no stepchildren, things like that, then the family structure you have determines whether, if it's really simple, maybe you can get away with a will. If there's no infighting and everybody is get along, go along now, and you expect that in the future. So family structure determines whether you can go with a will or whether you should go with a trust. Beneficiary selection, that is dependent upon whether you should get a will or a trust. Your need for privacy and your desire for asset protection. So that a will in most cases doesn't offer any asset protection, where an irrevocable trust for sure would offer some asset protection planning for you. Other considerations of which one is right for your estate: blended families and minor children or dependents that you have, or disabled beneficiaries. You have any of this, I often find that most people think that a trust helps them more efficiently than a will enable them to deal with a little bit more complicated distributions when you have blended families or minor children or dependents or handicapped or disabled beneficiaries. We'll summarize the will versus the trust. So the will, these were the parties: principal, PR is personal representative, and the beneficiaries. And a will opens probate. The trust, there's the grantor, the trustee, and the beneficiary. And you fund trust to avoid probate. Which is right for you? It depends on what your asset structure is, your family structure, and your beneficiary selection. A trust is right for you if you want to avoid probate, you want privacy of distributions, you might want to start a 5-year look-back period, you want to do some tax planning, especially Massachusetts currently in 2024 has a limit of approximately $2 million that every person can die with and give away at death without being taxed on, but over that amount you will be taxed. So there are certain trusts we do for tax planning if you're a married couple. That same tax planning is not available to single or unmarried people. And that a trust is right for you for if you're a special needs person, or if you have special needs people in your life, you want to preserve public benefits, but make sure that you can at least get some assets to that special needs person. So a will versus a trust. The steps to establish a will or a trust are very similar. And the process that you're going to go through to establish either or are that you would complete a questionnaire, and then a no-charge consultation is arranged where we discuss the people who you want to be in charge, who the trustees would be, who the personal representatives would be. And I go out 2 or 3 gyrations of, okay, you want this person, but if they're not available, then who do you want? And if they're not available, then who would you like to name as your trustee or personal representative? And then you decide who you're going to name as the beneficiaries of your estate and what percentage you would like to give them, or what specific bequest you might like to give them. And then 5 weeks later, we meet to sign your plan into action. So whether you're going to do a will or a trust, the process is the same on the front end of it. The process changes once This process is complete. Where a will, you don't have a lot to do because nothing really happens until after you pass away. Versus a trust, that document is a living and breathing document, a container where you're going to use that immediately. So we're going to retitle assets out of your individual name into the name of your trust. And that is how we're going to avoid probate. And if you do your estate planning with my firm, we oversee all of that process of getting your personal property into the trust, getting the real estate into the trust, and then we give you instructions on how to transfer your financial assets into your trust. If you work with a financial advisor, we work very closely with financial advisors and CPAs. We encourage almost all of our trust clients and people with wills that have enough of a net worth to really think about relying on your financial advisor as well as a tax professional and then your estate planning attorney to help meet you, get you answers for whatever life is going to throw your way. We call it the three-legged stool approach, that you have legal representation, you have financial representation, and you have tax representation, because those are the three legs of a stool that really are affected by almost any problem that you need to solve in life initially. So we're going to go into some questions and answers that are very common that I have gotten over the years. The first question, number one, is I have a will. I do not own any real estate. All of my bank accounts are jointly titled with one of my children. Will I avoid probate? Yes, you will. You will avoid probate. Even though you have a will, you're not going to need a will if your only assets are bank accounts that are jointly titled with someone else or have a beneficiary designation on them, such as the transfer on death or payable on death designation. I mentioned earlier, the downside of this is if you have 5 children and you only name one of your children, that legally, that one child that you have named jointly on that bank account is the only child that is legally entitled to the money in that bank account. Question number 2, I have a will. I own my home in my individual name. So now we're adding a house into this. All of my bank accounts are jointly titled with one of my children. Will I avoid probate? No. The home will require probate to transfer it to your beneficiaries or your heirs at law. So if you have a will, it's called named beneficiaries. If you don't have a will, it's referred to as your heirs at law. And that Massachusetts or New Hampshire, whatever state you're in, they will look at their legislation, their law to determine who is entitled to your assets, who are your heirs at law. The bank account will avoid probate, though, because that was jointly titled. I don't have a will, so no more will. My spouse, who has children from a first marriage, has already passed away. You own a house and a bank account in your individual name now. And you want your children, your birth children, and the stepchildren from your deceased spouse to equally inherit your estate. Will that happen? So, no. Without a will or a trust, only your birth children will inherit your estate under current Massachusetts law, because all of the assets are in your individual name. So the only people that are entitled to those assets, if you don't have a will, which is this case, are going to be your birth children. Question number 4. I have a will that names my spouse. So we have a will now, names my spouse, and then my children equally as beneficiaries. One of my children is disabled and is on public benefits. Will an inheritance to my disabled child disturb their benefits? So your will names my spouse and then your children. So what I also should have said here is that your spouse has predeceased you. So your spouse is not going to be receiving any assets, but your children will. So it depends on how the will is written. So if you want to make sure that a child with special needs who's on public benefits is that their public benefits are not disturbed, you want to look for supplemental needs language or special needs language in your will to make sure that it says any child of mine or beneficiary of mine who is who has special needs or disabled, that I want their assets to not go outright to them directly. I want them instead to be held in a special needs trust for them. If I own a house, would I avoid probate if I created a trust and transferred the deed to my house into the trust? Yes, you would avoid probate. Would my bank accounts that are in my individual name and without a payable on death beneficiary avoid probate? No, the bank accounts will not avoid probate. And why? Because you didn't transfer those bank accounts into the trust you created in the first question here above. But if you had taken the time to create your revocable trust, and we would transfer the deed to your house into the trust, and then you're going to take your trust to the bank and say, would you please transfer all of my bank accounts, checking accounts, savings accounts, money market accounts, CDs if you can, and transfer those into the name of your trust. That will avoid probate. So conclusions and next steps. What you need to do is to review your current estate plan. Do you have your cornerstone documents in place? I would like you for at least, at minimum, to have a will, have a durable power of attorney, have your 3 healthcare documents, that at minimum. And then to determine, depending upon what your family structure is, your need for privacy, what your wealth structure is, do you have real estate? You should really be looking at getting a trust. So would a will or a trust benefit your circumstances? So think about that. If you need some more information without having a consultation with my firm, you can go to my website, guthrolaw.com, where we have a lot of informational videos that we put more up just about every week or so that just describe commonly asked questions and terms. And then you can always contact our office to schedule a consultation for advice tailored to your unique situation. Most of the consultations for estate planning are at no charge after you complete that questionnaire, which was the steps I had mentioned earlier to obtaining information and getting started with your estate plan. If you're going to be looking into Medicaid asset protection planning, that is a billable consultation, only because at that 1 hour or 2 hour meeting, we really go over everything that you need to know to start your asset protection planning journey. So thank you very much for attending this presentation of a will versus a trust and which is right for your estate. I'm going to stop the share and we're going to go and take any questions from the group. Let's see if we can get this view to change a little bit. We'll go to speaker view. Okay, so anyone can put any questions in. You can all come off of mute if you would like to participate or speak. And there was one question in the chat that I can address, and that says, if one person or a married couple needs to be in a nursing home, can all of the couple's assets be transferred to the healthy person so the unhealthy person is eligible for Medicaid? So first, it's critical to know that it's a married couple. You cannot be an unmarried couple and get this same answer. So you have to be a married couple. And if someone needs to go into a nursing home, if you haven't done any 5-year look back planning and gotten yourself divested of assets? The answer to this is you are going to want to transfer all of the assets to the healthy person, because in order for, I'll call it a sick spouse, to be admitted into a nursing home and ask the government to pick up the bill using Medicaid, Mass Health, they can't have any more than $2,000 of assets in their name. So we need to transfer all the assets out of their name. But what's critical here is that you cannot protect all of those assets. You can protect, as a married couple, approximately $150,000 in assets and a house valued at about $1 million. So, as a married couple, when one of the spouses needs to go into a nursing home, you can protect a house valued at about $1 million, and then an additional $150,000 in assets. In addition to that, there are certain things you can do to qualify, or do prior to qualifying, is that you can prepay for your funerals. You can have a $1,500 burial account in each one of your names. You can have a car. So there are other things that you can do, but you cannot protect all of the assets. If only one spouse is alive and they need to go into a nursing home and the house is still in their name, that sick spouse, again, can only have $2,000 to their name. They can have the house in their name, but Mass Health is going to put a lien on the house and attach the house, that you will eventually have to sell the house. And Mass Health will be made whole for all of the money that they have fronted for that person's care. And if there is any money left after that, then the estate could get that money back. But I'll tell you, it runs about $150,000 to $180,000 a year to have someone in a nursing home. So you can see, with that amount of cost, you're going to be going through money quite quickly. And oftentimes there isn't any money left after Mass Health gets reimbursed. Let's see what else. Does the PA for the will not have fiduciary responsibilities? You said the trustee does. So the PA, it's also the personal representative. It's actually PR is the acronym we use for shorthand. So the PR does have fiduciary duties as well, and they are obligated to follow through. But there is a lot of wiggle room in the probate process, that depending upon what type of probate has been opened, there's three types pretty much. That there's either court supervision throughout the whole process or not. So that once someone is appointed as the personal representative, oftentimes that gives somebody a license to kind of start doing whatever they feel like they need to do. Sometimes they'll follow what the will says, and sometimes they don't. And that's where all the battles ensue. So that they do have a fiduciary duty. It's just a little bit, there's a lot more wiggle room with a will. But to answer your question, yes, they do have, they have to follow the prudent investor rule, that they have to try to distribute the assets as fast as possible. They have to invest the assets to protect them in the event the stock market's going up and down. I normally say to my personal representatives, you probably want to liquidate those assets or put them into very safe holdings. If we're in a volatile market, maybe you're going to take them out of equities and you're going to put them into bonds, or you're going to move it into a money market. But that's really between you and the investment advisors, that you really do need to protect the assets, whether you are a trustee or whether you're a personal representative. Karen asked, if your house is paid, is the only way to protect it from suit is an irrevocable trust? That, or giving it away, Karen, to people now? So if you don't own it, then your creditor you're judgment proof. They can't give you something that you don't own. You can't make someone a creditor can't come after you for assets that you don't own. So in that case, a creditor, so is the house, if the house is paid, is the only way to protect it from suit in an irrevocable trust. Most of the time, yes, or to give it away to somebody so you don't own it. In the irrevocable trust that I do for Medicaid asset protection planning, I can leave it so that you can have some control over it, that you can decide to maybe change the beneficiaries during your lifetime. But sometimes that leaves you open to creditor claims that they say, hey, listen, you were able to change who the beneficiaries were. So, change it back to you and then we'll attach it. But even with that said, for a Medicaid asset protection trust, I specifically state in my trust, you can change the beneficiaries, but under no conditions can that beneficiary be you. I don't even allow you to be trustee of your trust if we're doing a Medicaid asset protection trust.
So
Because, go ahead.
So if it's in an irrevocable trust, it can't be changed. So you can't take it out of that.
No.
Once it's in that's for life.
Yes.
Okay.
You could put certain terms in the irrevocable trust that say when it terminates, such as you could say this trust terminates in 20 years and it shall be distributed to the named beneficiaries. So if your children are the named beneficiaries of that trust, then you're no longer involved at all and it goes to the kids. An example of that where it's a little more painful is that if we create the Medicaid Asset Protection Trust and we name that you can change who the beneficiaries are up until the day you die through your will, it's an exception with Mass Health that you're allowed to do that. Currently, it's always changing. And then if you have $100,000 bank account and you want to start protecting the 5-year look back period on that as well. Well, you're getting the income generated off of that. And in a 6% rate environment right now, right, that 6% of 100,000, if the trust is yours and you can pull the income off of it every year, that's great. But if you put that terminates in 20 years, you've just shut yourself off of that income that could be earned. Other people take the irrevocable trust, put their house into it, and then maybe they're going to go live with one of their children, but they're going to rent their house out and get some income off of it. Or they might go into an assisted living and they're going to use the income generated off of their house rental to pay for their assisted living. So as long as you're getting the income and profits off of it, that's something that you can do. But if you're hoping to take that house, transfer it into the Medicaid Asset Protection Trust, start the 5-year look back period, and then in 20 years, when you decide you're going to go into an assisted living because you don't think you're going to need a nursing home, and you want to pay $6,000 to $9,000 a month for assisted living and have a hotel style lifestyle when in your later years, and get to one level living, get rid of the stairs and the washing machine and all of that, and really just have a little bit better life for yourself in an assisted living facility. You can't sell the real estate and use that money to pay for your assisted living because you divested yourself of that asset to start the 5-year look back period. So I'm telling you, legally, you're not supposed to do that. Have I seen people do it? Yes. But if they ever need a long-term care facility and they see that that money from that trust was ever used to pay for anything that benefited you, Mass Health is going to try to bust that trust open and say whatever money is left in that is up for grabs to pay for your assisted living, and you're not going to qualify for Mass Health because of that.
Thank you.
Thank you.
Who else has got something for me? I have something here. In general, what are the costs of going through probate? Well, Lori, that's a loaded question because that really is dependent upon what your asset structure is. If you don't have a trust, if you don't have any real estate and it's just financial assets and that you don't have many of them, or you have a lot of them and they're in one brokerage house and you wanted to go through your will and you didn't name beneficiaries. The least amount of money I've seen probate go for where there's assets that it's not the voluntary probate where you have to have less than $25,000 in a car. That I can do for like $1,000 or $2,000. But regular probate, from my experience, from me doing it, normally is minimum between $5,000 and $8,000. And that it's not uncommon to see them to go as high as $20,000 to take 2, 3, 4 years. I have some that are going 5 years. If you get a disgruntled beneficiary or you get a personal representative who didn't do the right thing, or if we get a child who went in and raided the personal property before anybody else had a chance to go in, right? And because the personal representative is in charge of the personal property the second the testator dies, right? The principal dies. The moment the principal dies, the personal representative should really be going in, changing the locks on the house. And this is very hard when you have 5 kids and they all have a key, right? And then one of them shows up and they can't get in. But it's really what should be done. And then all the other kids are angry at the personal representative because what are you doing? We're all get along, go along until, I mean, the personal property grab, the jewelry grab, it's very common. And there is nothing oftentimes that you can do other than the personal representative, if they're not the ones that did the grab, can bring a lawsuit against the person that went in and took the items. But even then, it gets into a he said, she said match. And now the personal representative has to have proof. And then what I see when it goes into litigation, which I do not do litigation, but my peers do, is every time the child says, Mom or Dad gave me that before they died. I didn't go in and take it. Mom and Dad gave it to me before they died. They wanted me to have it. So then you've got ill will, and then you've also got another countersuit. So I do recommend, though, if you do have items of personal affection that you want to go to someone, even if you have them in your will, I don't hesitate with having to distribute those things during your lifetime. Because it's really lovely to see a smile on the face of the person that you're going to give it to. So don't wait until the end. And you can even reduce your taxable estate by gifting prior to death. Right? That's another technique to reduce your taxable estate. Let's see, in general. So that's in general the probate costs. What is an income-only irrevocable trust? I saw it somewhere. It's on my materials on my website. An income-only irrevocable trust is another name for a Medicaid asset protection trust, which the example I gave earlier is you create this irrevocable trust. And in this irrevocable trust, you transfer the $100,000 bank account. And you are entitled to get the income. So that's why it's called an income-only irrevocable trust. But you are not entitled to the $100,000 principal. So you're entitled to the income generated annually, but not to the $100,000 principal in my example. So Let's see. Anybody else have any great questions for me? This is a good time. Do you have any questions on the material that I presented? The difference between a will and a trust, or were there any people out there that felt that a will avoided probate? That's something I get a lot. Oh, done perfectly. Thank you, Giselle. Appreciate that. So in general terms, then in summary, if we don't have any other questions, that again, I encourage you to go to my website. There's a lot of videos there. Oftentimes I'll take one of these presentations and I will have a site that my clients can go and watch them. Sometimes I open them up as well to the public to watch it. Oh, here it was. Can I get a link to a recording of this? If I do this recording, and I will try to at least send it to all of you if it is, but you can also check on my website. Someone asked, how does a revocable trust reduce estate taxes? Lori, are you a married couple?
Yes.
Okay.
Yes.
So it's a special trust, and it's called a tax planning trust. And if you're familiar with credit shelter tax planning, so what it does is you start with one trust while you're both alive. And then on the first to pass, we create two subtrusts. One is called the credit shelter trust or the family trust. The other one is called the marital trust. And currently, there's a $2 million Massachusetts estate tax exemption. The federal tax exemption is 13.9, but expected to come down at the end of next year to about $5 or $6 million. So we could fund up to whatever the federal or the state exemption is into one of those subtrusts, and then we put everything else into the marital trust. So whatever we put into that family trust, that credit shelter trust, when the second of you dies, is not pulled into the survivor's taxable estate. So for many clients that have less than $4 million and they're married, I will, on the first to pass away, fund the credit shelter trust with $2 million. And then on the second to die, I counsel you to make sure that your estate is under $2 million. And that is the way that a married couple can have more than $2 million and not pay any Massachusetts estate taxes on the second to die, as long as we've gotten you under the collective, $4 million exemption, or really it's on the second to die. We want that their estate to be under 2 million. Now, it's not uncommon on the first to die. If we fund, say, with that initial $2 million, all of the money is available to the surviving spouse, I should add. So you still have total access to that money. But we kind of do a shell game by giving it a separate tax ID number. That 2 million, I have seen, well, the 2 million exemption is new, right? It was $1 million last year. I have seen that million grow to $4 million. So if we hadn't done that credit shelter tax planning, and it was all still in the last to die's estate, we're going to get a very large Massachusetts estate tax. Versus if you had just done that credit shelter tax planning with the marital trust, then we could have at least sheltered 2 million, right? And then it's still available, even that 2 million for the surviving spouse. Now, you do have to run a little interference at the surviving spouse getting at the money. And I say interference because I say, I don't want the surviving spouse to get at that money until they've gone through all the money in the marital trust, that second trust, and I only really want them to get at it for their health, education, maintenance, or support. But if they need to get at it to buy a boat, because that's what they want, or to buy a condo in Florida, which they never had before, I ask them to appoint an independent trustee, normally a CPA or an attorney or a friend, that is giving the okay. Because they have to keep in mind that your children are really the ultimate beneficiaries of that. And we want to make sure that you maybe haven't done a second marriage and you're trying to get the money to really be used for the benefit of maybe a new spouse. Because your first spouse really wanted that money to be used for your children and for you, not on a remarriage. So we try to run a little interference on that. And I work with you if that's the way that you decide to go to do some tax planning, that the money is still available for the surviving spouse, but we're trying to do a little bit of a shell game from a tax perspective, get a new tax ID number for that family trust, and then move it into have it still available for the surviving spouse. So that when the surviving spouse passes away, then it all will go to the children or whomever you've named as beneficiaries. Can
Thank you.
there be two co-trustees as well as being beneficiaries? Absolutely. You can have as many beneficiaries and as many trustees as you want. It's nice when there's co-trustees that they're sharing the burden. It's a thankless job, I should add. A lot of people want to be it, but once you are it, you wish you weren't it because it's just really a lot of work being a trustee or a personal representative for that matter. So if you have co-trustees, you want to say whether they have to act together or they can act independently. Whenever there's a transfer of real estate, you're required to have both of them acting together. But yes, co-trustees can be. Sometimes it's a little bit easier not having co-trustees because there's only one person that has to make the decisions. And sometimes there are, when are we going to liquidate these accounts? What are we going to sell the house? Like that's the biggest thing. Like a lot of kids are like, this was the house we grew up in. We don't want to sell it. Why don't we rent it? And you need somebody that knows what your wishes were and can pull the trigger on saying, nope, if you want this house so much, then you can buy everybody out of the house and you can, use your inheritance and the money to buy them out. And we're going to sell the house. And yes, you can have the first right to buy it, but you're going to buy it at fair market value. You're not going to get a discount because any discount that we would give you would be to the detriment of the other beneficiaries. Unless you told me in your trust that that's what you wanted to give any child that wants to buy the house 10% discount, then every one of them is going to want to buy it, get the 10% discount, and then sell it and make 10%. So I try to walk you through all these very odd situations that can happen. So I don't see any other questions. So again, if you want to do something further with my firm, we'd be happy to help you out. You can just email the email that you have been, office at guthrolaw.com. There's also a link on my website to contact us, fill out the form, and then we'll send you a questionnaire. The questionnaire can be filled out online, digitally, as well as printed out and mailed in or dropped off at our office in our Dropbox. And then once you fill out the questionnaire, it really tells me kind of a quick summary of what your assets look like. Tell me who are the three people in order you want to make financial decisions for you, and who are the three people you want to make medical decisions for you. And then when we meet, normally via a Zoom call, I review your questionnaire with you. I kind of have it figured out whether you'd benefit from a trust, whether you'd benefit from a tax trust, whether you want to do Medicaid asset protection planning based upon your age and health status. And then we just kind of talk at that meeting. I ask you what your goal is. And I ask you, are there any children or beneficiaries with addiction or special needs? So I can do that planning built into your plan. And then if you want to move forward, I send you an engagement agreement with a price quote in it. You can DocuSign it if you want, or handwritten, drop it off, pay by check or credit card. And normally within 5 weeks, you're sitting down here with me and my staff, and we are signing your plan into fruition. And then if it's a will, you're really ready to go. I want you to put your healthcare documents on file with your doctor's office, your durable powers of attorney on file with all your financial institutions if you don't have a trust. And then if you have a trust, I take care of funding it with your real estate. And then I give you the direction to transfer all of your financial assets into it. And I work with your financial advisor, if you have one, to help guide them through the funding process with that. But other than that, I have someone on here that has done work with me, and they might want to comment. Did you find, or any of you, there's a couple of you, have you found the funding instructions efficient? So, yeah, so it's really quite clear. But if you can get your assets into your trust during your lifetime, you will avoid probate. And believe me, your beneficiaries or your trustees will be very happy that you did it. So thank you very much again. There's a number of ways to contact my firm for helping you out, and it's really been a pleasure to have all of you here, and look forward to working with some of you, and for some of my clients that have come on in to just get ramped up again with the process. Nice to see some familiar, friendly faces. Thank you very much.
If you would like help or have questions about this information, please give us a call at 781-229-0555 or visit our website at guthrolaw.com. We look forward to hearing from you.